Hello friends, welcome to EPG Pathshala on the subject Penology and Sentencing. I am Mrs. Tushita Gaur Sharma, Assistant Professor Law at the Vivekananda Law School, Vivekananda Institute of Professional Studies, affiliated to the Guru Gobind Singh Indraprastha University, Delhi. In today's discussion, we shall look into the module on aspects related to the transcendental and the utilitarian theories of punishment as encompassed in the field of criminology. The theories of punishment are a controversial and frequently debated topic. This controversy is mainly because the satisfactory justification on the one hand and the practical application on the other of the theories of punishment is one of the most important and complex problems in ethics in terms of philosophy of justice. It has been found that punishment policies have many origins. However, the extent to which new philosophical dogmas precede the commencement of any policy is often open to question. Apparently, these philosophical dogmas are more often rationalizations of existing policies. It would not be very off the mark to suggest that principles of punishment have been logically deduced from greater principles. For instance, punishment comes from the concept of abstract justice of divine will. Such principles have certainly had an influence in externalizing the existing penal practices in the face of changed circumstances. The most important feature of the theories of punishment to be seen is that at the global development level, when we study punishment, we have essentially classified the need to punish in terms of two general philosophies. The first is the transcendental philosophy and the second is the utilitarian theory. Now, looking at the transcendental ideology of punishment, it was developed alongside the notions of natural law and philosophy. The transcendent ideology, whether it was religious or mystical, is quite simply a metaphysical justification for the need of punishment in the legal setup. The sacredness of certain rights can be derived from the wrongs inflicted by the offenders and also from the horrors derived from such wrongs. In this context, the transcendental philosophy justifies punishment because it is something well deserved by the offender, thereby making the protection of those sacred rights vital importance to the horrors which need to be avoided and not repeated from the past. Thus, we find that the transcendental philosophy is essentially retributive in nature and therefore the retributive theory of punishment. But there is one difference because it does not harbor any objective in terms of a future advantage which may be gained from punishment as such. So, what end product is, we leave out the deterrent theory of punishment. The main focus of the retributive theory are basically three. First, the primary justification of punishment is that offense deserves punishment. Secondly, the offender must be accordingly punished as a corollary to the first. Next, punishment is by itself an end. Thirdly, the philosophy follows the objective that the guilty should suffer pain. Under the retributive theory, offenders are punished for criminal behavior because they deserve punishment. Criminal behavior upsets the peaceful balance of society, and punishment helps to restore that lost balance as such. The retributive theory focuses on the crime itself as the reason for imposing punishment. Human beings have free will and are capable of making rational decisions. An offender who is insane or is otherwise incompetent should not be punished. However, a person who makes a conscious choice to upset the balance of society must be punished. There are basically 5 types of transcendental philosophies. The first is the theological view, which upholds the duty to punish as a religious duty. Second is the expiatory theory view, which says that we must punish because the nature of the mystical order of the universe is that we punish. So, however, this one provides a very indistinct logic to the idea of punishment as such. The third kind of transcendental theory is the one given by Kant of moral law. He believed in an intuitive source of absolute morality. The first main focus of Kant is on moral law. Next, Kant also insisted that there exists a categorical imperative to punish the criminals who have violated this moral law. Punishment is therefore an end in itself. The theory of Hegel is the fourth type of transcendental theories. In this, punishment is necessary to annul the injury produced by crime. The fifth and the last category or type of transcendental theory is the aesthetic theory of punishment. Our aesthetic sense rebels against the discord produced by crime. Punishment provides the verification, therefore we punish. One of the most well-known passages of Immanuel Kant's The Metaphysic of Morals is, and I quote, "Even if a civil society were dissolved through the unanimous vote of its members, for example, if an island society decided to dissolve with its members, spreading themselves over the rest of the earth, the last murderer within the prison first must be executed so that he experiences what his own deeds are worth, and the blood guilt does not cling on to the society at a later point of time." In fact, punishment, according to Kant, is so that it can be seen as having participated in that public violation of justice. I unquote. For Kant, the general deterrence was the justification for criminal law provisions threatening punishment. Retribution, on the other hand, was not a goal or a reason for punishment, but rather it was a limitation on the state's right to inflict punishment, and thereby a form of insurance that the individual would not be treated as a means to some social goal, but rather always as an end in himself. The distinction between the reason for threatening and the reason for executing punishment has had historical roots in the period which preceded and which also directly followed Kant's time. That punishment was threatened to deter criminal violations is also supported explicitly in much of Kant's work which preceded the Metaphysic of Morals. In addition, punishment as coercive deterrence follows from the necessary nature of law within Kant's theory of justice. After a criminal violation has occurred, the focus shifts from instrumental priorities of general crime prevention to the just treatment of the individual as such. Most of Kant's explicit decision or discussion on criminal law theory in Metaphysics of Morals is directed towards this particular role of punishment. The Kantian notion of the categorical imperative plays out in the transcendental theory of punishment. We can find the theory propounded by Hegel to show its influence as well. Hegel's main thrust has been that punishment is necessary to annul the injury produced by crime, and this can be seen foremost in the transcendental philosophies itself. In the words of Hegel, and I quote, "Crime has to be punished because it postulates punishment as its necessary logical complement. Since violence or force in its very conception destroys itself, its principle is that it must be cancelled by force. Hence, it is not only right but necessary that a second exercise of force should annul and supersede the first." Unquote. The oft quoted statement wherein the criminal act and the punishment are inseparable finds theoretical ground. The criminal act is a negation and punishment is the negation of a negation. There are different moral bases for retribution. To many jurists of the retributivist theory, punishment is justified as a form of vengeance. Wrongdoers should be forced to suffer because they have forced others to suffer by the doing of their acts. This ancient principle was expressed succinctly in the Old Testament of the Judeo-Christian Bible, which states, and I quote again, "When a man causes a disfigurement in his neighbor, it shall be done to him, fracture for fracture, eye for eye, tooth for tooth." Unquote. To other theorists, retribution against a wrongdoer is justified to protect the legitimate rights of both society as well as the offender. Society shows its respect for the free will of the wrongdoer through the punishment. If you do something wrong, society is equally free to inflict punishment upon you. Punishment also shows respect for the offender because it allows an offender to pay the debt to society and then return to society, theoretically free of guilt and stigma. since you have already undergone the punishment and now you are free of your punishment, you are also free of that stigma or that guilt, etc. Now moving on to the second part of our module today, we talk about the utilitarian ideology of punishment. The main aim of the utilitarians was to prevent crime. Since capitalism was at its pinnacle and social living was abreast with the notions of profit and loss, everything was to be accounted for in the balance sheet. Therefore, it held that man's actions are governed by rational assessments of pleasure and pain. Thus, punishment should also be only just sufficient to produce a net loss, that is a pain, over the pleasure. The utilitarian theory of punishment seeks to punish the offenders to discourage or deter future wrongdoings. This is the main point where we find the difference between the utilitarian ideology and the retributive ideology. In the retributive ideology, there is no chance or there is no scope or goal which focuses on future. Whereas in utilitarian, everything is in terms of present pleasure, past pain, or past pleasure and now pain. So it is a kind of a juxtaposition that if you are given pain today for your past wrong, you will tomorrow not do the same wrong again. Thus, it is just the opposite of the retributive or the transcendental philosophy. So there is no objective future consideration under the retributive theory. Under the utilitarian model, punishment is a necessary evil, firstly. Secondly, it is justified as a means to prevention of greater evils. Thirdly, it is also used as a method of reducing the incidence of criminal behavior, because if there are instances of criminal behavior and they are subsequently sufficiently ordained with punishments, then automatically the theory of behavioral pattern is that the number of crime incidences will reduce by, first of all, deterring the potential offenders, or by preventing repeat offences, or by reforming the offenders who have already been committing the offence. Under the utilitarian philosophy, laws should be used to maximize the happiness of society, which is why the term or the terminology maximum happiness for the maximum number is used or associated with utilitarian concept. Because crime and punishment are inconsistent with happiness, they should be kept to a minimum. But the utilitarians understood that a crime-free society does not exist, and it is only a utopian idea. You can never have a society where there is no crime. Whenever there is a group of people or there is a society, crime will automatically be there, because it is human nature to try and usurp another's property, another's body, etc. But the endeavor to inflict is, under utilitarian, only as much punishment as is required to prevent future crimes. The utilitarian theory is therefore consequentialist in nature. It recognizes that punishment has consequences for both the offender as well as the society, and therefore it holds that the total good which is produced by punishment should exceed the total evil, meaning thereby punishment should not be unlimited. One of the illustrations of consequentialism is in punishment is the release of a prison inmate who has been suffering from a severe illness. If the prisoner's death is imminent, society is not going to be served by his continued confinement, because he is anyway no longer capable of committing any crime, so why should he be continued to be put into captivity? Under the utilitarian philosophy, laws that specify punishment for criminal conduct should be designed to deter future criminal conduct. This is the main thrust. Deterrence operates on a specific and a general level. As far as general deterrence is concerned, it means that punishment should prevent other people from committing criminal acts, and the punishment serves as an example to the rest of the society. Therefore, it is a direct deterrent effect of that punishment. And on notice that such criminal behavior will be punished accordingly. On the other hand, we have the specific deterrence. Specific deterrence means that the punishment should prevent the same person from committing the same crime or similar crimes again. Specific deterrence also can work in two ways. First is when the offender may be put in jail or prison to physically prevent him from committing another crime for a specified period of time, that is till the person is put under incapacitation. Second, this incapacitation is designed to be so unpleasant that it will discourage the offender from repeating their offence for a repeat time or a repeat offence of criminal behaviour. Now, another important utilitarian rationale for punishment is what is called rehabilitation. The goal of rehabilitation is to prevent future crime by giving offenders the ability to succeed within the confines of the law. Now, what is very interesting in terms of rehabilitation is that once a person has committed an offence or a crime and thereby is punished for that offence, that person has now already entered into the vicious circle of crime and its subsequent adjudication. Rehabilitative measures for criminal offenders are usually including treatment for afflictions like, for example, any mental illness, any kind of a chemical dependency or drugs, etc., any chronic violent behavior that the person is otherwise used to. Rehabilitation also includes the use of educational programs that give offenders the knowledge and skills needed to compete in the job market. This is very important factor, particularly in Indian scenario. We have seen that the jails have reformed themselves and they have now started incorporating skill development programs for all inmates, whether they are under trials or they are the actual offenders who are undergoing punishment. For instance, in the Tihar jail, they have started with yoga exercises, whereby they give mental peace to the offender or the inmate. Also, they are doing educational activities, whereby they are given certain degrees, etc., by the various universities across the country, and so that once the person is released from prison and comes out, the person is equipped with a professional degree or a degree so as to equip themselves with a job in the market. A third major rationale for punishment is the denunciation. Now, under the denunciation theory, punishment should be an expression of societal condemnation. The denunciation theory is a hybrid of utilitarianism on one hand and retribution on the other hand. So, it is a kind of a mix between the two. It can be called utilitarian because of the prospect of being publicly denounced serves as a deterrent factor. Denunciation can also likewise be termed as retributive in nature because it promotes the idea that offenders deserve to be punished. Now we move on to the next part of this module, which focuses on the application of the theories of punishment in the Indian criminal justice system. The philosophy that came to have its most powerful sway in the administration of Indian criminal justice system was the utilitarian philosophy. English utilitarianism was an offshoot of the Western liberal ideas. English utilitarianism owed its genesis to the ideas of Bentham. The utilitarian philosophy believed in the maximum good of the greatest number, and it's extrapolating it in quantifiable terms also. Several administrative and judicial reforms in India were the result and cause of utilitarianism. From the time the British began their intervention into the legal and administrative foray, we find that Lord Cornwallis worked mainly with the ideas and perceptions which came before utilitarianism, while on the other hand, Lord Macaulay, who was a liberal and he had grown up in the interaction with both the missionary zeal of evangelicalism and the emerging pragmatism of the 1830s and 1840s, so we can see that he has taken up the codification of laws with vigor. Though he approved of this aspect of institutionalism, he did not at all agree with the goal of reforming India. The Code of Criminal Procedure 1973 as such, if we look at, has outlined a very well articulated criminal law enforcement mechanism. It has carved a web of rules through which a criminal proceeding needs to move on, and also of the procedural requirements that need to be met with different stages of criminal proceeding. The CRPC has enumerated a set of rules of procedure to be followed during investigation, 'investigation, 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 ' Now, the consequential criminal liability also finds a place in the fields of the provisions of the Code of Criminal Procedure 1973. Under the code, we can easily see the reflection of the utilitarian model in terms of the administration and the functioning of courts, as well as in the punishments which are meted out by the courts. For instance, in the case of State of Punjab versus Prem Sagar, which is a 2008 judgment of the Supreme Court, where the court has awarded the sentence, the court said that although a wide discretion has been conferred upon the court in interpreting the statute, the same must be exercised in a judicious manner. While awarding the sentence, the principle to be borne in mind is that the nature of the offence said to have been committed by the accused plays a very pivotal and important role. The court went on to observe that a sentence is a judgment on conviction of a crime. It is resorted to after a person is convicted of the offence. It is the ultimate goal of any justice delivery system. The Parliament, however, in providing for a hearing on sentence, as would appear from subsection 2 of section 235 of the CRPC, also subsection 2 of section 248, section 325, as well as sections 360 and 361 of the Code of Criminal Procedure, has laid down certain principles. These provisions lay down the principle that the court, in awarding this sentence, must take into consideration a large number of relevant factors. These factors could be with regard to the sociological backdrop of the accused, because very often in India we find the accused having been belonging to the poorest of the poor strata, not being educated, so illiteracy is one of the issues because they do not know about their rights, they do not even know about what is right and wrong, that discernibility is not present, all of which points towards utilitarian model of punishment as opposed to the retributive or the transcendental philosophy of punishment. Now, when we look at section 235 subclause 2 in particular, we see that this particular section is on sentence hearing prior to the conviction of the offender. Now, this particular thing is a very basic right which has been afforded to the offender in the Indian criminal justice system. In fact, the older CRPC of 1898 did not have this particular provision, and this was added in the 1973 new Code of Criminal Procedure. Now, when we talk about all types of trials which take place before a court of sessions, or any of the trials which are done or dealt with as warrant cases by magistrates, the court, after finding the accused guilty, is required to hear the convicted accused on the question of sentence and then to pass the sentence on him according to law. Here, the court must take into consideration various factors such as, first, the nature of the crime committed. The prior criminal record of the offender must be brought to book. The age of the offender, if it is a very young offender, then accordingly there should be some kind of leniency accorded and afforded to him. The gender of the offender is also sometimes important and must be noted. The possibility of treatment that could be there means whether the person, if given sufficient treatment or rehabilitative and reformative treatment, would be able to go back into society and not be a recurrent or a repeat offender. Any other aggravating or a mitigating factor which could be considered. For example, it is very often found that the offender is actually the sole breadwinner in the family, and accordingly, therefore, it is expected that the person is to be treated in a more lenient manner and the punishment should accordingly be awarded. Besides this very important provision, the Code of Criminal Procedure also contains the provisions for reasoned decisions, or which are also called speaking orders. In the landmark judgment of the state of Maharashtra versus Gorakshak Ambaji Adsul of 2011, Honorable Mr. Justice Swatantra Kumar of the Supreme Court has articulated upon the requirement under section 354 of the CRPC in the following words, and I quote, "Awarding punishment is certainly an onerous function in the dispensation of criminal justice. The court is expected to keep in mind the facts and circumstances of a case, the principles of law governing award of sentence, the legislative intent of special or general statute all of these are raised in the case, and the impact of these must be seen while awarding the punishment. These are the nuances which need to be examined by the court with discernment and in depth, unquote. Under section 354, which is on the provision which deals with the language and other contents of the judgments in criminal cases, we find the following important aspects. Particularly when the conviction is for an offence which is punishable with death, or in the alternative with an imprisonment for life or imprisonment for a specific number of years, the judgment shall state the reasons for the sentence awarded. Or in the case of a death sentence, the special reasons for such death sentence which is being awarded must also be specifically mentioned. Another very important provision is the one given in section 360, which is on order to release on probation of good conduct or after admonition, which again falls within the ambit of the utilitarian concept. Because the moment a person is found to be guilty, but there are mitigating circumstances like the age, etc. of the person, then very often the court may find it important not to put the person under actual punishment by putting the person to have a prison term. Rather, they may even just admonish the person and thereafter release them. Now, this concept is very similar, also found in section 248 of the code, which is on acquittal or conviction of the accused. This again deals with the utilitarian ideology. Once proven guilty, you have to undergo the imprisonment, which is neither less nor more in the sense of being adequate or commensurate to the offence as such, keeping all other antecedents of the offender in consideration. Once acquitted, the person is free of all charges and his reputation is also not compromised in any manner merely for having undergone that particular trial. Now, with this, I'd like to conclude the module. It may be concluded that in the Indian context, the tussle between utilitarian and retributive ideologies has been conquered by the utilitarianism, and secondly, the relevance of the utility theory has far outnumbered the other philosophies of punishment. Our legal system shows its adherence to utilitarian ideals in the creation of systems such as pre-trial diversion programs, probation and parole. These systems seek to limit punishment to the extent necessary to protect society. The utilitarian philosophy is also reflected in the assignment of different punishments for different crimes and in the notion that the amount of punishment a convicted criminal receives should be in proportion to the harm caused by that particular crime. So, it must be commensurate. For example, if a murder calls for imprisonment or even for that matter the death penalty, a simple case of assault where no serious injuries have been normally caused is to be punished with a very small jail sentence, or maybe a probation or a fine also would be sufficient. A sentence may, however, combine utilitarian ideas along with retributive ideas. For example, an offender is sentenced to prison for several years and therefore is sent to the prison to quench the public's thirst for vengeance. This becomes retributive in nature. At the same time, there are certain educational programs which are taking place within the prison complex which are having a rehabilitative and therefore also a utilitarian goal. Now, with this, we conclude the module on transcendental and utilitarian theories of punishment in the subject of penology and sentencing. I hope the module has been successful in providing you with a clear understanding on the concepts of transcendentalism, the ideologies of Kant, Hegel and other philosophers on retributive theory of punishment, as well as the utilitarian theory and how it came to the fore along with capitalism ideology based on the economic balance sheet of profit and loss model, where everything is for the greatest good, that is the pleasure of the maximum number. Thank you for watching the video. Have a nice day.